Good morning. I hereby call to order this 8th meeting of the Pennsylvania Public Utility Commission for the year 2023. I welcome everyone here that's with us and those that are watching us on our live stream. And now we ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As a reminder to everyone, today's meeting, which is open to the public, the commission will act on various matters. Also, another reminder that there's no opportunity for the public to address the commission at these public meetings. The public meeting motions, statements, and video will be available on the commission's website later today. So our first matter on this morning's agenda is the approval of the minutes of May 18, 2023. And I turn to Commissioner Zerfus to acknowledge her. She is the editor of the minutes.
Thank you, Madam Chair. I have reviewed the minutes of the May 18, 2023 public meeting and move that they be approved as submitted.
You have heard the motion to approve the minutes. Is there a second?
Second.
Second by Commissioner Coleman. Any further discussion on the minutes? Hearing none, all those in favor of approval, please say aye.
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 Any opposed, please say no. The minutes are approved 5-0. And now, without objection, we will turn to our Secretary Rosemary Chiavetta, Secretary of the Commission, to walk us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners. Your various bureaus and offices have prepared the following agenda for your consideration. Therefore, let us begin on page 1 with the recommendation of Director Monahan and the Bureau of Audits that the Commission adopt the gas cost rate audit report of the Northeast Heat and Light Company and release the report to the public.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Yonora, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 5-0.
Turning to page 2 and matters presented by Acting Director Hafner and the Office of Special Assistants. It is recommended that the Commission adopt the proposed opinion and order in the petitions filed in response to the petition of the Office of Consumer Advocate, the Office of Small Business Advocate, and the Pennsylvania Utility Law Project regarding the Federal Infrastructure Investment and Jobs Act.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfus. Any discussion?
Madam Chairman?
Vice Chairman.
Thank you. Just briefly, I wanted to make a few comments on this matter. I wanted to thank the parties involved for bringing this matter before us. As many of you know, I'm a new commissioner, and I appreciate opportunities of cases of first impression. Hopefully, the decisions we make here today will be used by future commissions, so I appreciate that. Also, we want to do everything possible we can to encourage as many public utilities to go after this unprecedented federal money available to them. This designation is what it is a treatment as the costs associated with IIJA applications to be treated as a regulatory asset. We want to encourage as much utilities as possible to apply for that funding. And if this certainty, or this designation, I should say, helps you to do that, all the better. Finally, I do want to point out that cost recovery is a separate issue here, that this is treatment of these costs as a regulatory asset for accounting purposes, and that whether they are reimbursed or not is a matter of a rate case, and those decisions will be made there. And finally, as terms of the docket here, we appreciate the designation as a regulatory asset, what information that brings and will be deposited in this docket. So we have a one-stop shop for the public to see all of this information coming back. So again, I appreciate the petitioners for bringing this matter before us. Thank you, Madam Chairman.
Thank you, Vice Chairman. Is there any further discussion or comments?
Madam Chair?
Commissioner Zerfus.
Madam Chair, I would just like to associate myself with the Vice Chair's comments. Thank you.
Thank you very much. Any further discussion or comments? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed, please say no. The motion passes 5-0.
Continuing on page 2, it is recommended that the Commission adopt in an omnibus motion, the second item on page 2, the formal complaint of Matthew Forgy, care of Megan Forgy, versus the PECO Energy Company Electric Division, and continuing the omnibus on page 3 to include both items on page 3, and ending the omnibus motion with the application of Dennis Nolt.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Yonora, second by Vice Chairman DeFrank. Any discussion? Hearing none. All those in favor, please say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 4, and matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion both items on page 4, beginning with the tentative order canceling the licenses of certain electric generation suppliers, and continuing the omnibus to include both items on page 5, both items on page 6, both items on page 7, both items on page 8, and ending the omnibus motion at the top of page 9 with the letter of notification filed by the West Penn Power Company.
Is there a motion to adopt these staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Zerfus, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 5-0.
Continuing at the bottom of page 9, it is recommended that the Commission adopt the quarterly earnings report of fixed utilities and make the report public.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfus. Any discussion?
Madam Chairman,
Vice Chairman.
I have a statement that I would just like to enter for the record. And I will be brief as to that statement. With this report, the Commission publishes financial information for our major fixed utilities and establishes a return of equity to be used in DISC calculations. In reviewing the ROE trends in the marketplace, most notably the discounted cash flow results, I find the following adjustments to be in the public interest. First, an increase in the electric industry ROE of 10 basis points. The electric industry DCF has increased significantly as of recent and is prudent to adjust in response to that trend. Secondly, maintaining the DISC ROE for the natural gas industry at its current rate. This industry ROE has been fairly steady in recent quarters, and stability supports maintaining the current ROE. And finally, a reduction of 10 basis points in the water industry. The industry's DCF has dropped 79 basis points in the past year. Consequently, a gradual adjustment downward is warranted to reflect these market circumstances. I believe these small revisions strike the appropriate balance of continuing to support robust investment by utilities while also instilling reasonable rates for the Commonwealth's residential, small business, commercial, and industrial customers. Thank you, Madam Chairman.
Thank you, Vice Chairman. Any further discussion or comments?
Yes, Madam Chair, I do have some brief comments.
Commissioner Yonora.
I support the increase in the DISC return on the equity for electric industry and maintaining the gas at the current rate, but I do not support the decrease in the water industry at this time. Since the three industries are contained in one report, I will dissent in part and will be recorded as a no vote. Thank you.
Thank you very much. Any further discussion or comments?
Chairman, I'm going to associate myself with Commissioner Yonora's statement.
Thank you, Commissioner Coleman. Any further discussion or comments? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed?
No.
No.
The motion passes 3-2, noting that Commissioner Yunora and Commissioner Coleman are dissenting in part. Is that correct?
Correct.
Okay, thank you.
Turning to page 10, and matters presented by Acting Executive Deputy Chief Counsel Screven and the Law Bureau. It is recommended that the Commission adopt in an omnibus motion both items on page 10, beginning with the proposed water audit methodology regulation and ending the omnibus with the petition for reconsideration filed by Energy Link LLC.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 11, it should be noted that the proposed rulemaking to amend the Pennsylvania Universal Service Fund regulations has been postponed until the public meeting of August 3rd, 2023. Turning to page 12, and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge. It is recommended in an omnibus motion that the Commission adopt the initial decision of ALJ Hoyer in the formal complaint of Stephanie Person versus the People's Natural Gas Company, and end the omnibus on page 12 by adopting the initial decision of ALJ Ashton in the formal complaint of Frida Willis versus the PECO Energy Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman DeFrank. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 5-0.
Turning to page 13, it is recommended that the Commission adopt the initial decision of ALJ Heap in the formal complaint of Ann Wilson versus the PECO Energy Company Electric Division.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfus. Any discussion?
Madam Chair.
Commissioner Zerfus.
Madam Chair, I have a motion in this matter, but before I get to the motion, I would like a little indulgence, please, to build a little context for the motion. But for the folks back home, this is the third public meeting that we're having motions of this, similar motions that we're about to have now, the next four, and I just wanted to build a little context or background as to why we're doing what we're doing today, but in a way that's kind of outside the language of a motion or a statement and kind of talk about it like we're at the kitchen table. But what we are trying to do today is take up particular cases. So we have these particular cases with particular group of people in a particular timeline that fit a particular fact pattern. So we have before us pro se complainants who did not affirmatively select or agree to being served by the Commission through email. That's one. They were then served by the Commission through email. They were served hearing documents through email. They then missed their scheduled hearings. And then most, if not all of these cases were then dismissed with prejudice, meaning that they can't come back ever to fight the case again. I think there's a disagreement or a discussion or a question of whether or not the Commission fulfilled its obligations to properly serve these hearing documents to these folks. And that's what we're doing here today. We're trying to course correct what I think is an issue in service of these documents. Now, the statute and the regulations stipulate very particular circumstances in a way that these people receive their hearing documents. Largely these people, complainants are supposed to be getting their hearing documents through mail unless they select email or they, agree to it, each party agrees to the email. Now, we have this complicated issue where during a particular time frame, the pandemic, we had you'll hear a waiver order, right? We've heard that in the past couple meetings. This waiver order waived our regulations on service so we can communicate with folks through email. Makes sense during a pandemic, right? We're all at home, we're not getting our hair cut, government still needs to work. This is the best way during a pandemic to communicate with folks. A lot of people did it, a lot of agencies did it. Agencies that are not independent agencies mostly to carry these things through legislation, not regulations, but here we are. And it's complicated because we have this waiver of certain service, but the statute still says that you need to be served through mail unless you agree to email. In these particular cases, these people did not affirmatively select or agree to the email, so that's why we have these cases that we have here. We're not calling up every single case or every single matter or every single issue that has come up through the pandemic because they all don't fit this fact pattern. This fact pattern is very particular, it's very specific. We have a growing number of folks within this particular time period who missed their hearings and then were dismissed with prejudice. I am questioning whether or not we fulfilled our obligations underneath the statute and the Constitution to properly notify them and to give them their opportunity to be heard. So that's what we're doing. We're giving them another opportunity to be heard. We're not fully remanding these issues. We're not asking everyone to come in and file new complaints. It's just an opportunity to get another bite of the apple to be heard. So again, we may have a disagreement on whether or not we meet these obligations, but I would submit that even if there's a shred of doubt or a question or a modicum of doubt, we should err on the side of caution to make sure we are fulfilling our duties under the Constitution regarding due process. So in that context, I have this motion, which, Madam Chair, Madam Secretary, I will read it as if I read it into its entirety. I would ask that it be added to the public record, please. But in this particular circumstance, on July 18th, 2022, Ann Wilson filed a formal complaint alleging that PECO Energy Company, I'll just call them PECO, was threatening to terminate her electric service and that there were incorrect charges on her bill. For relief, Ms. Wilson requested fair, accurate billing. On August 11th, 2022, PECO filed an answer denying that the material averments in the complaint, stating that the charges and billing for the complainant were correct. On October 27th, 2022, a hearing notice was sent by email, and thereafter a pre-hearing order providing the date and the time of the hearing was sent by email to Ms. Wilson. The hearing convened as scheduled on January 11th. Counsel for PECO appeared with 2 witnesses, however, the complainant did not. Thereafter, her case was dismissed with prejudice. I submit that this case is similar to the Commission's recent decision of Robert Hoyt v. Columbia Gas of PA. The order was entered on May 30th, 2023. First, in Hoyt, the Commission determined that the practice of dismissing complaints by pro se complainants with prejudice when there is no record of the complainant agreeing to service by email and the complainant fails to appear at the hearing is inconsistent with due process. The Commission found that there is no need to close the door to this venue to pro se complainants unless record evidence shows that they are abusing the Commission's administrative process to avoid their utility bills. The same reasoning applies here in this case because there is no evidence of abuse of administrative process. So for that reason, I submit it is not appropriate to dismiss the complaint with prejudice. Second, the Commission determined in Hoyt that when the Commission serves the hearing notice by email, not returned as undeliverable, to a complainant who did not elect to receive notice through the Commission's e-filing or e-service system or otherwise agree to service by email, the Commission may not presume that the complainant received the notice of the hearing for purposes of satisfying due process. So similarly here, the complainant did not elect to receive documents through e-service or otherwise agree to be served notice of the proceedings related to her formal complaint by email. Therefore, the Commission's decision in Hoyt, the Commission may not presume that the complainant received her hearing notice or pre-hearing order. For these reasons, I submit that the complainant did not receive adequate notice of the hearing to preserve her due process. And lastly, in Hoyt, the Commission determined that it was in the public interest to afford a complainant an opportunity for an evidentiary hearing if the complainant elects one. I submit that this case is similar to Hoyt in this manner as well. So therefore, I move that the initial decision of Administrative Law Judge Darlene Davis Heap issued on April 5th, 2023, is modified consistent with this motion. That the complainant be afforded an opportunity to file a written request for an evidentiary hearing within 20 days of the entry of our order in this matter. That if a written request for an evidentiary hearing is timely filed, the proceedings shall be remanded to the Office of Administrative Law Judge for further proceedings as warranted for the issuance of an initial decision on remand. And if a written request for an evidentiary hearing is not timely filed, the complainant shall be dismissed without prejudice, but without further action of the Commission. That the Office of Special Assistants prepare an order consistent with this motion, and that the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Thank you.
You have heard the motion of Commissioner Zerfus. Is there a second?
Second.
Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, I do have some comments I'd like to add to the record.
Commissioner Coleman.
Thank you. Well, I'm not sure where to start here this morning, and I guess maybe with another apology to all of you in the audience and those of you joining us online. You've had to endure this process for several public meetings, and that's unfortunate. In my opinion, this is kind of the inside baseball and airing the dirty laundry on the process of this commission. When we go back in time to what we're doing here and what we're discussing this morning, we're in the midst of a global pandemic, and we are doing all that we can. At that time, the three of us, Chairman Dutrell, Commissioner Yanora, and myself, were on the bench, and we're doing all that we can to keep this organization running. And during that period of time, we approved unanimously waivers for this organization over 3 separate occasions that gave this team, our utility team, the ability to operate in a nimble way. And I just, again, want to thank the team for doing a fabulous job, for doing all that they could do within the waivers that we approved to continue operation. This morning, we're reaching a milestone, and I think it's truly an unfortunate milestone. That is that the 11 cases that Commissioner Zerfus has brought forward have now made it through our process. They've made it through our Office of Special Assistants, and those orders have been entered. And so what had been the way of doing business is now turned to this new precedent as a result of these motions. And again, I think that if we're going to do something like that, that we need to have a clear path that indicates why we are changing our course, why we're taking a course correction. And in my opinion, we haven't done that. 3 public meetings ago, when we talked about this, I started my comments on this matter and said that I thought that this would be a robust conversation of constitutional construction. And we get right into the heart of why we're doing what we're doing. And we set forth and distinguish very clearly for all to see why we are changing our course on how we handle pro se complainants. And we haven't done that. That's not what we've done. This is a majority that has decided to change course and has not clearly distinguished why we are changing that course and direction. I appreciate what Commissioner Zerfus has put forth this morning in terms of a very specific set of facts here and a fact pattern of these complainants. And when I apply that fact pattern and I look at all of those complainants that meet that fact pattern during this period of time as we're in the midst of a pandemic, it's not just a couple of dozen, it's over 1,000. It's over 1,000 pro se complainants that have been served electronically as permitted in the waiver orders that we, the 3 commissioners, approved. So if we truly are interested in getting to the bottom of what we believe or that the majority believes is a violation of due process, then we really should look at all 1,000+ complainants that were served electronically during that period of time. Now, I would not be advocating for that because I believe that those complainants who provided us their email addresses on the complaint form and were served consistent with the waiver order that 3 commissioners have approved were served properly. So again, I think it's unfortunate that we're here again this morning, and perhaps this will be the last time you'll hear from me in such a extended statement this morning on these matters, but I think it just needs to be said that I believe that this team operated under the waiver orders that the 3 commissioners sitting on this bench has approved. And I think that if we are going to change course and direction from what we approved in those waiver orders, then we should have afforded an opportunity for all parties to be able to comment before we took this course correction. So one could even argue that we violated the due process of those folks involved and covered by the waiver order. But let's not go down that path. Hopefully this is the end of this. We can put this behind us and we can move on to smoother waters and blue skies for this organization. So I apologize to all of you here this morning that had to be subject to this. I apologize to the team of this organization, and I want you to know from me that you did exactly what we asked you to do in the waiver orders that these 3 commissioners have approved. And I apologize that you've had to endure this process, and I apologize to your team members that had to stand on the front line during this period of time. So thank you. I appreciate it. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further comments? Let me say I do have comments to place on the record. Appreciate the passion behind this main issue. And the reason why I can say I appreciate the passion behind it is because since 2013, I have been sitting on this bench, either as a commissioner or as the chair, talking about my concerns with dismissal with prejudice. So I haven't changed my course at all, and I intend to walk out of this door probably sooner than you guys want, maybe not, I don't know, with the same passion and concern in terms of dismissal with prejudice. So I appreciate the discussion on this. I appreciate the differences in opinion. I appreciate the passion behind it, and I hope that we can move forward and continue to discuss it as a commission. Any further comments or concerns?
Madam Chair.
Commissioner Zerfus.
Thank you, Madam Chair. I appreciate those comments, and I do appreciate the comments of Commissioner Coleman. However, I will respectfully disagree, and I am not going to apologize for sitting here and protecting people's constitutional rights of due process. So I will sit here and I will bring up these motions as long as I possibly can, as long as they're coming before me, where in this particular set of circumstances with these particular group of people, in this particular timeline, I think there's a question of whether or not they were served properly. But ultimately, we are controlled by the Constitution, right? So we have these inalienable rights that we cannot waive, rights that are granted to individuals, to him, to her, to them by the U.S. Constitution, the Pennsylvania Constitution, the administrative agency law, the Public Utility Code, and case law. I am not going to apologize for doing everything I can for the people back home to know that government works for them and that we are here to protect their rights. You can talk about, I worked in state government too during the pandemic, not here at the PUC. Lots of amazing things happened through the pandemic. People had put forward Herculean efforts to make government work, and we all did that. This is not a question or an exercise of integrity or ethics or ability. This is a test of being able to be self-aware, to self-correct a process breakdown, even if it's unintentional. You can waive whatever you want to waive, I guess, with the best of intentions for administrative efficiencies, to get through a global pandemic, but you cannot waive rights granted to you by the Constitution. And if there is even a question of whether or not we fulfilled our obligation to protect those rights, even a question, we should err on the side of caution. We should want to give deference to the folks back home who entrust us to give them a fair shake, to prove to them that government works. Why is deference important? Because these cases before us are not just docket numbers. These are real people we're talking about. These cases involve real people back home with real problems who count on us to ensure a fair shake in these very real and complicated issues. We are talking about customers of all income levels. They may be asking for payment arrangements. They may have health problems or medical bills or young children. They may have trouble making ends meet, or they have service issues. In many of these cases, customers have had their utilities terminated or they're about to be terminated. These customers are our neighbors, our loved ones, and our friends. They are also Pennsylvania taxpayers, ratepayers, and consumers. In some of these cases that have come up before us during the course of these motions in the past meetings, folks could have been afforded PUC payment arrangements, but they were never afforded the opportunity to receive one because they were quickly dismissed and with prejudice, simply because they missed their hearing, a hearing that they may or may not have even known about. Could it have been because of the service issues? I would say so, probably. Could it have been because of life? Maybe. I could be an armchair psychologist and go through the reasons why people miss hearings, why we forget things, why life happens. But again, that's back to if there is a shadow of doubt, if there is any kind of doubt, we side we side with caution. So that saying that individuals have 20 days to come back and request a hearing that they missed if they so choose, maybe they don't, but if they so choose, because they may not have received a hearing notice that we sent in a manner that they didn't choose, pursuant to a waiver they may or may not have known about, it's the least we can do to fulfill our obligations under the Constitution. These are inalienable rights. We have a duty as an agency to protect those rights. If there is a shadow of doubt, we must err on the side of caution. Thank you.
Thank you, Commissioner Zerfus. Any further discussion?
Chairman, in the heat of my passion on this, I forgot to enter the joint statement of Commissioner Yora and myself. So I would ask that the joint statement of Commissioner Yora and myself be entered into the record as though we read it in its entirety. And the statement is similar to those that we entered into the record of the public meeting of May 18, 2023 for the cases involving the same issues raised in the same motion. So thank you.
Thank you, Commissioner Coleman. Any further comments or discussion? Hearing none. Now we are voting on the motion offered by Commissioner Zerfus. All those in favor, please say aye.
Aye.
Aye. Any opposed?
Nope.
No.
The motion passes 3-2, noting the dissent of Commissioner Yonora and Commissioner Coleman. On the matter as amended, is there any objection to taking the previous roll call? No. Matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Yonora.
Continuing on page 13, it is recommended that the commission adopt the initial decision of ALJ Johnson in the formal complaint of Corinne Hales versus the Pennsylvania Electric Company.
Is there a motion to adopt the staff recommendation? So moved. Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfus. Any discussion?
Madam Chair.
Commissioner Zerfus.
Madam Chair, Madam Secretary, I have a motion in this matter. I will read it as if I'm reading it in its entirety. Please add it to the public record. But on August 24th, 2022, Corinne Hales filed a formal complaint alleging that Pennsylvania Electric Company, I'll call them Penelec, had terminated her electric service. On September 15th, 2022, Penelec filed an answer in new matter. Penelec stated that it terminated service to the complainant based on her outstanding arrearages, but that it had restored her service due to the complainant's presentation of a medical certificate. On December 20th, 2022, a hearing notice was sent by email. Thereafter, a pre-hearing order providing the date and time of the hearing was sent by email. The hearing convened as scheduled on February 3rd, 2023. Counsel for Penelec appeared with one witness, however, the complainant did not. Thereafter, the case was dismissed with prejudice. I submit that this case is also similar to the Commission's recent decision in Robert Hoyt v. Columbia Gas of Pennsylvania. The order was entered May 30th, 2023. So therefore, I move that the initial decision of Administrative Law Judge Conrad A. Johnson issued on April 12, 2023, is modified consistent with this motion. That the complainant be provided an opportunity to file a written request for an evidentiary hearing within 20 days of the entry of her order in this matter. That if a written request for an evidentiary hearing is timely filed, the proceeding shall be remanded to the Office of Administrative Law Judge for further proceedings as warranted and for the issuance of an initial decision on remand. That if a written request for an evidentiary hearing is not timely filed, the complaint shall be dismissed but without prejudice, without further action of the Commission. And that the Office of Special Assistants prepare an order consistent with this motion, and that the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Thank you.
You have heard the motion of Commissioner Zurfas. Is there a second?
Second.
Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, Commissioner Unor and I have a joint statement that will last entered in the record. Thank you.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. We are voting on the motion. All those in favor, please say aye.
Aye.
Aye. Any opposed?
Nope.
The motion passes 3-2. On the matter as amended, is any objection to taking the previous roll call? Hearing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Unora.
Turning to page 14, it is recommended that the Commission adopt the initial decision of ALJ Chiodo in the formal complaint of Tasca Taylor versus the Pennsylvania Electric Company.
Is there a motion to adopt the staff recommendation? So moved. Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zurfas. Any discussion?
Madam Chair.
Commissioner Zurfas.
Madam Chair, Madam Secretary, I have a motion in this matter. Please add it to the public record. I will read it as if I'm reading it in its entirety. But on November 14th, 2022, Tasca Taylor filed a formal complaint alleging that Pennsylvania Electric Company, PENELEC, was threatening to terminate her electric service. For relief, Ms. Taylor requested that the Commission establish a payment arrangement for her. On December 5th, 2022, PENELEC filed an answer denying that the complainant is legally entitled to a Commission-ordered payment arrangement. On December 9th, 2022, a hearing notice was sent by email. Thereafter, a pre-hearing order providing the date and time of the hearing was sent by email. The hearing convened as scheduled on February 9th, 2023. Counsel for PENELEC appeared with one witness, however, the complainant did not. Thereafter, the case was dismissed with prejudice. I submit that this case is also similar to the Commission's recent decision in Robert Hoyt v. Columbia Gas of Pennsylvania, where the order was entered May 30th, 2023. So therefore, I move that the initial decision of Administrative Law Judge Katrina Dunderdale, issued on April 18th, 2023, I'm on the right one, right? Yeah. Is modified consistent with this motion, that the complainant be provided an opportunity to file a written request for an evidentiary hearing within 20 days of the entry of the order of this matter, that if a written request for an evidentiary hearing is timely filed, the proceeding shall be remanded to the Office of Administrative Law Judge for further proceedings as warranted and for the issuance of an initial decision on remand. That if a written request for an evidentiary hearing is not timely filed, the complaint shall be dismissed but without prejudice and without further action of the Commission. That the Office of Special Assistants prepare an order consistent with this motion, and that the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Thank you.
You have heard the motion of Commissioner Zurfas. Is there a second?
Second.
Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, Commissioner Unor and I have a joint statement on this matter, and I asked it to be entered in the record as though we read it in its entirety. Thank you.
Thank you very much, Commissioner Coleman. Any further discussion on the motion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Any opposed?
Nope.
No.
The motion passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Unora. Is there any objection to taking the previous roll call for the matter as amended? Did I already do that? No. No. The matter as amended passes 3-2. I'm sorry. Noting the dissent of Commissioner Unora and Commissioner Coleman.
And finally, on page 14, it is recommended that the Commission adopt the initial decision of ALJ Dunderdale in the formal complaint of MacArthur Giles versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation? So moved. Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfus. Any discussion?
Madam Chair.
Commissioner Zerfus.
Madam Chair, I have a motion in this matter. I will read it as if I'm reading it in its entirety. Please add it to the public record. But on November 9th, 2022, MacArthur Giles filed a formal complaint alleging that Philadelphia Gas Works, PGW, had shut off his natural gas service and requested a payment arrangement that he could afford. On December 7th, 2022, PGW filed an answer acknowledging that it terminated service at the service address and alleging that the termination was due to the complainant's failure to pay monthly bills in full. On December 13th, 2022, a hearing notice was sent by email. Thereafter, a pre-hearing order providing the date and time of the hearing was sent by email. The hearing convened as scheduled on February 17th, 2023. Counsel for PGW appeared with the witness, however, the complainant did not, and thereafter, the case was dismissed with prejudice. I submit that this case is also similar to the Commission's recent order and decision in Robert Hoyt v. Columbia Gas. The order was entered on May 30th, 2023. So therefore, I move that. And I realize I made a mistake the last time. That's why I'm kind of like a little befuddled here. The initial decision of Administrative Law Judge Katrina Dunderdale, issued on April 18, 2023, is modified consistent with this motion, that the complainant be provided an opportunity to file a written request for an evidentiary hearing within 20 days of the entry of the order in this matter, that if a written request for an evidentiary hearing is timely filed, the proceedings shall be remanded to the Office of Administrative Law Judge for further proceedings as warranted and for the issuance of an initial decision on remand. That if a written request for an evidentiary hearing is not timely filed, the complaint shall be dismissed but without prejudice, without further action of the Commission. That the Office of Special Assistants prepare an order consistent with this motion, and that the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Madam Chair, may I ask a question quickly before we go to the vote here?
You asking me a question?
Yeah. So, I mean, I want to submit the motion. I have like a parliamentary question
Okay,
or
parliamentary procedure.
point of order or whatever they say over at the legislature, right? So,
We say that here, too.
do we? Okay.
You just haven't done it.
Okay. So, point of order. In this issue, this MacArthur Giles motion that I just read, which I read correctly, that I'd like to submit, and then hopefully we take this vote on this one, I realized that I had switched the ordering paragraphs from the last one, the Tasca-Taylor and the MacArthur-Giles. I don't know if I need, when we finish this one, if I have
We
to do
can
something.
correct the record.
Okay.
We'll correct.
All right, so we'll end
Finish
this.
this one, then
Okay.
correct the record for the last
Okay,
one.
thank you. So I did this one correctly, so I'm done with the motion of MacArthur-Giles. Thank you.
You have heard the motion of Commissioner Zerfus. Is there a second?
Second.
Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, I would ask that the joint statement of Commissioner Yenora and myself be entered the record so we read it in its entirety. Thank you.
Thank you very much, Commissioner Coleman. Any further discussion on the motion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed?
No?
No.
The motion passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Yenora. On the matter as amended, is there any objection to taking the previous roll call? Hearing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Yenora and Commissioner Coleman. Now, if there's no objection, we can go back to, what was the case? The
Tasca-Taylor case.
Well, if there's no objection, we'll go back to the Tasca-Taylor case and allow Commissioner Zerfus to correct the record on her statement. You're recognized.
Okay.
I don't hear any objection.
Okay. Thank you. Thank you, Madam Chair. I wanted to correct the record. I realized that in the ordering paragraphs, I kind of switched up the names of the administrative law judges and a date. So I wanted to correct the record that on Tasca Taylor motion, I move that the initial decision of Administrative Law Judge Gail Kyoto issued on April 6, 2023 is modified, consistent with the motion. So for the two, I kind of switched the judges and the dates. So I don't know if I have to go any further and read the rest of it, or if that's enough to correct the record.
So I think that's enough to correct the record, because your written motion will be on the record, and that will be correct.
That's sufficient.
But I wanted to give you that opportunity, and because I've never done it, you know, I love this parliamentary procedure stuff.
Is it a point of order or a parliamentary inquiry? Point of order? Either one?
It's usually point of order.
Okay.
So,
All right. You're welcome.
okay. All right, Madam Secretary.
Turning to page 15. It is recommended that the commission adopt the recommended decision of ALJ Ashton in the gas cost rate filing and proposed tariff supplement of the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you very much. We have no other business before us. With that, I will entertain a motion to adjourn.
So moved.
Is there a second?
Second.
Double seconds, okay. Motion by Vice Chairman DeFrank, double seconds by Commissioner Unora and Coleman. I'm sure there's no discussion. All those in favor of adjourning, please say aye.
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 Any opposed? We are adjourned. Thank you, everyone.